Good afternoon, good evening, depending on where you're joining us from. Welcome to this webinar and thank you so much for making time. My name is Miriam Beatrice Wanjiru. I will be coordinating and moderating this entire session. We are hosting this as part of celebrating the Data Privacy Day here at Paradigm Initiative. And why exactly are we doing this? We are looking at it as a moment to reflect not only on laws and policies, but basically having a conversation on how exactly it is to practically implement laws and policies and rights, and how then do we enforce what is already in existence. Today's discussion will walk us through real cases with a special focus from Kenya, Uganda, and Tanzania, and we'll basically be unpacking what these data protection cases mean for accountability and what regulatory gaps, if any, are there, and how can we then collectively work together for a better data protection future across the continent. Before we start, a few housekeeping rules. This session will be recorded, as you've heard. And secondly, we will also live stream so that we can reach as many people as possible. In case you have any question, feel free to use the chat box. I'm sure you've done this multiple times before. We will definitely spare some time towards the end of the webinar to answer most of the questions that you will ask. And we intend very much to only make use of 1.5 hours. So please do stick around. We will try as much as possible not to spill over. That said, let's begin. Let's start. Feel welcome. Let us know where you're joining us from. So just feel free to share your name, organization, and the country that you're joining us from. We are joined here by a fantastic lineup of speakers who are doing some amazing work when it comes to data protection across East Africa and beyond. But before I introduce you to our speakers, let me first introduce our Senior Manager, Partnerships and Engagement here at Paradigm Initiative, just for a quick welcome note, and then we'll get to know our speakers a bit later. Tobekile, over to you.
Thank you so much, Miriam, and a special welcome to everyone joining us today for this fantastic conversation on Data Privacy Day. So happy Data Privacy Day to everyone, and a special welcome as well to all the facilitators and speakers on this call. As already been introduced, I'm Tobekile Matimbe, and I work for Paradigm Initiative as Senior Manager, Partnerships and Engagements, but very strongly an advocate for data privacy. So today being a very critical day, the reason for it is to build awareness, raise awareness, capacitate individuals on how they can keep their data safe. And it's one of those days that we take time to stop and reflect at what is on what is available for us in terms of strengthening our privacy. So as we start, obviously, it's important to highlight, I think, some of the themes that are going around in commemoration of today. And particularly what stands out is the theme of taking control of your data. So as I've been reflecting on what that means for myself as an individual and as well broadly for the African continent, I've had time to stop and reflect on the possibilities of individuals actually taking control of their data. So as we know, data is very important. It's precious. It identifies who we are. It's linked to, our very being. It's linked to our human dignity. So the things that are associated with what is out there called data, this could be our personal information, our national identity. It could be information about where we live, who our family members are. It also could be, our direct location of where we can be easily accessible. So when you think about this, data is currency, data is money, data is valuable, data needs to be safeguarded, and data needs to be protected. In this view, I think one thing that is very important to think about is how possible then is it for our data to be under our control if we do not have self-agency and have the ability to actually protect ourselves and protect our personal data. As a starting point, it is always important that we reflect on how we can ensure that our data is safeguarded As much as we freely give it, at least we should freely give it, we should be able to ensure that even when we want to withhold that data, we have the ability to withhold that data. That is what self-agency is all about. The ability to know that our data is precious, is valuable, it needs to be safeguarded, is part of self-agency. Looking at it from that premise, it then begs the question, after we have had that agency, that ability to know what our data should be, taken as, how our data should be protected by others. The question is, what then happens? Why do we then have data privacy concerns? This is looking at the broader ecosystem. We have various actors who collect our data. So what do they do with that data? Do they safeguard it? And if they don't, is there a mechanism of accountability? Which takes us to the great facilitators we have on this call who are doing great work to ensure that there's some form of accountability. It is not only enough for us to have self-agency, we also need to have agency in an environment that enables the protection of our data. So what we're also looking at as well is the existence of legislation and policies that enable an ecosystem where data privacy is a lived reality. As we are looking at the continent today, we have a wave of data protection legislation in at least 40 countries. And when you're looking at it from that premise, to what extent are those laws and policies safeguarding data privacy? This is something that is really important. And again, there have been instances where violations have happened. Has there been accountability for violations where data privacy is not safeguarded? So when you're looking at data protection, we have adequate legislation on the continent, I would say. Of course, we have some countries that are still coming up to speed on the African continent. Countries like Namibia, for instance, are still trying to play catch up around data privacy through data protection legislation. But to what extent have those laws enabled protections and safeguards for data privacy? To what extent as well have those laws become fully operationalized through the existence of data protection authorities that deliver independently, on human rights protections? So it's all a matrix of, assessment in terms of all the key stakeholders that should, put their hands to the plow to ensure that data privacy is a lived reality. When you think about it, with all these laws that we have, why then do we still have data breaches? Why then do we have even companies not complying and sticking to, due diligence processes to ensure that data is safeguarded? Why then do we have instances even when companies as well fall short of doing what they need to do, or even find themselves sharing data that needs to be safeguarded with third parties? Why do we see that happening? This also, again, touches on the issue of accountability. So, like I said earlier, we've got a good lineup of panelists who are going to, unpack some of the key cases that have been handled in judiciaries in East Africa, just to show us what accountability looks like and what accountability should be, not just in East Africa, but in other African parts as well. We are seeing really a slow growth in terms of jurisprudence that is addressing data privacy. And we would ideally want to see more steps and more strides in other sub-regions of the African continent as well with regards to promoting data privacy. As an organization at Paradigm Initiative, we've already been doing work to advance the development of jurisprudence on the African continent as well with regards to promoting and protecting data privacy. Like I said, data is money. Data is, it's a resource and we need to safeguard it. It starts with us, our self-agency. It starts also with enabling policies and legislation, but it should end with accountability. So thank you so much as you settle in and listen to the fantastic, fantastic submissions. Brace yourself and don't forget to protect your data.
Hashtag don't forget to protect your data. Thank you so much, Tobekile, for such powerful opening remarks. And in case you're just joining us, this is our special edition of Data Privacy Day webinar, and we will be focusing on what is happening in the region, particularly in East Africa, and what other parts of the continent can borrow, can learn. So look at this as a learning opportunity, cross-border learning opportunity. I know you're all joining from different parts of the continent. Let's see what we can borrow from different experiences. That said, Tobekile is actually right that East Africa, we've been having a buzz of data protection cases. In fact, if you are in Kenya, I'm sure yesterday you saw on the papers that one of the top schools in Nairobi, they were tasked or they were asked to pay a little over 600,000 to a parent whose image was used without consent. So it's impossible to go a week without seeing a data protection or data violation, something in relation to that. So as I mentioned, today we'll only be focusing on a few cases, not to say that these are the only data protection landmark cases in the region, but we've selectively chosen this because they, in the words of one of the lawyers here, they've been shaking the continent. And if you do not know about them, this is your opportunity to see that, slowly but surely, different countries are implementing and enforcing what is already in existence in terms of data protection laws. So I will not go into the details, but allow me to please introduce our panelists to you. I will start with Rose. Rose, if you are here, please just say hi to the masses as we also check your mic, who you are, where are you from, and how are you feeling this Data Privacy Day?
Wonderful. Good afternoon, everyone. My name is Rose Musero. I am a data protection and cybersecurity expert under the EARDIP project, which is an East African Regional Development integrated project with World Bank. And I advise the East African community on data protection and cybersecurity issues. Previously was the Deputy Data Commissioner for Kenya, heading the compliance department. Glad to be here, specifically on Data Protection Day. I think it's wonderful to see how far we've come. I remember when we were celebrating the first Data Protection Day and much of East Africa wasn't fully participating, to now, almost 6 years later, seeing the vibrant engagement. So really, really glad to be here and excited for this discussion. Thank you so much.
Wonderful, thank you. We'll bring you back a bit later. Joshua, hi, I see you. Who are you? Where are you from? And what do you do?
Yes, hi everyone. Hi Miriam. Yes, my name is Joshua Malizo Nyawa. I am an advocate of the High Court of Kenya, and currently I serve as a litigation counsel for rule of law and good governance at Katiba Institute in Kenya. Yeah, it's a pleasure being here. Thank you so much.
Thank you, Joshua. You forgot to mention that you're also part of the team that really made WorldCoin have a run for their money. But yeah, we'll speak about that at length. Raymond,
Yes.
I see you smiling. Who are you? What do you do?
Good morning, good afternoon, good evening, everyone. Happy Data Privacy Day. My name is Raymond Amumpire. I'm an advocate of the courts of judicature in Uganda, and also do a lot of, some work at the intersection of the law and tech. I'm happy to be here as well. Thank you.
Thank you, Raymond. Tito, confirming you're there.
Yes, I'm here. I was failing to unmute myself. But can you unmute my mic? Because hey, what happened?
We can hear you. We can actually hear you.
Right.
Oh, thanks. Hi, colleagues. I am Tito Magoti. I practice law in Tanzania and in our regional courts. I also do some work at the intersection of human rights and technology, and very much happy to to share my 2 cents today in this symposium. Asante sana.
Thank you, Asante. You're all being very modest. So if Tito is not chasing the government, he's running away from the government. There's always something. But we love your work in the region. So we'll dive right in. So how we intend to have this conversation is we will focus on three big cases that have shaken the continent in the past couple of years when it comes to data protection. And then from that, we will have a brief panel discussion so that we learn, what are the challenges when you're pursuing these cases. So most of the people you've had pursued these cases, firsthand. So we want to learn as much as possible from them. And we will start with Uganda. Just a few minutes, take us through the case against Google. That was really, really huge, made headlines across the region and beyond. So let me just try and share your slides, Raymond. But feel free to, just start your remarks. And in case you're joining, you're welcome to our Data Privacy Day webinar.
All right, thank you so much, Beatrice. So I'll just share a little bit about the Google case as it has come to be known, but a complaint by me and 3 colleagues, Frank Sekamwa, Lenisha and Pamela, and Awino Masi at the Personal Data Protection Office in Uganda. So the complaint is complaint number 8/11 of 2024. So on the 9th of October, which is Uganda's Independence Day, because we sort of wanted to premise this case on asserting our sovereignty, our digital sovereignty. We went for Independence Day, which was the 9th. We did write to Google LLC and informed them of their obligation to actually register with the Personal Data Protection Office in Uganda, as is mandated under the law. So a series of events happened, and it all led to the decision that was delivered on July 18th of 2025, just last year. And I'll just share a little bit about that. So we brought this case against Google as, concerned Ugandan citizens in our capacity in the
Raymond, we seem to be losing you. Raymond, if you can hear me. Hi, Raymond. Hi, Raymond, can you hear me? Okay, technology happens all the time. We're used to these things. So as Raymond fixes his internet, I would want us to save a bit of time and look at a fantastic case that was pursued by Tito from Tanzania. And basically, Tito, as you walk through your presentation, I'm really curious to know, because I know there was an appeal. Where are you with the case? What is the case all about, by the way, and what inspired you to pursue the case? So, Tito, if you're there, we can just start with Tanzania, and then we'll come back to Raymond for sure.
Yes, I've requested to share my screen. Am I allowed? Oh yeah, say yes, share. Let me. Yeah, I hope I should be able to share my screen. Allow.
And if you're having challenges, just let me know. I already have your.
In fact, I amended my presentation significantly.
Oh.
Yeah.
Since when we spoke, okay.
Yeah. So is my screen visible?
Yes, please go ahead.
Okay, great. So slideshow from start, that is not useful. So yes, Miriam, thank you so much again for having us. In substance, our regime is our data governance regime is still very infant, very young, such that we only had the law 2 years ago. So the regime is very much young, but we love the fact that this law was in place thanks to efforts of campaigners, including ourselves, until such time when the government took over. It is when they drafted the law beyond the stipulates of what the consultative team had thought it would it would be human rights oriented, if you like. So our law is new, as I said, but then the government did what it did, having in place provisions that we thought are not compatible with the Constitution. They defeat the purposes, the intent of some of the provisions of the Constitution, especially safeguarding fundamental rights to privacy, but also, assumption of powers, especially when appointments are done single-handedly, including appointment of, the Data Protection Commission, but also powers of the minister, to determine appeals in a very conflicting way, but also, nuances around data collection, data storage, but also, crimes emanating from the act itself. So we went to court in 2022 with my colleague Jebra Kambole to try to invite the court, the High Court of Tanzania in Dar es Salaam, to look into the provisions that we thought are broader, ambiguous, but also those that are egregious, which affects various provisions of the Constitution. We had taken a very lengthy approach. Sometimes we try to see how should we go to court. We have I see here we had more than 10 provisions that we thought they are defeating the purpose of the Constitution, or rather they are deemed unconstitutional in our perspective. And then we said, how should we go? Let's take all the provisions, and it's going to be for the court to determine. And as I said, some of the contestations in substance includes the president to appoint the chairman and vice chairman of the Data Protection Committee without prescribing qualifications or procedures, because we know principally that any authority such as that of the president has to be oriented on some procedural requirements that help to determine the outcome. If you empower an individual, or rather an institution, to single-handedly pick someone, they might end up cherry picking, but also they might abuse that power. So we think such appointments that are made without competition, without openness, may lead to arbitrary appointments. However, the court said, the lack of explicit procedure does not inherently render the provision unconstitutional. We thought the rules, the regulations would now provide for the processes and the procedure that would lead the president to determine, to do the appointments. However, the regulation themselves, they do not provide for such, procedures. So there's a whole other list of provisions. I would say out of all the provisions we had petitioned, more than 10 provisions, the court granted 2 provisions with their 4 sub provisions, which I'm going to speak to briefly. But I want to briefly also speak to the other provisions that the court thought they are constitutional, including on crimes. stipulated in the law. There are certain crimes stipulated in the Data Protection Act, which principally we thought they are strict liability because the guilt mind, which is required as an element of proving a crime, is not clearly stipulated. It's not clearly displayed how it could be weighed for the court or for an authority to arrive to a conclusion that this person is at fault in terms of this law. However, the court decided not in our favor. Appeals to the minister, whom we think he also vets some of the individuals who are board members of the Data Protection Act, of the Data Protection Commission. We thought that appealing to the same person who appointed them is not compatible with some of the principles of administrative justice. However, the court thought powers of the minister can yet be contested by way of judicial review. So they thought that provision is great. But also some exceptions for processing of some data that are given to certain authorities and public agencies. We thought such powers might be abused. However, the court thought, the exception is justified given the mandate of those institutions. But we call the victory registered. Oftentimes in strategy litigation, we don't call something a win, but rather a progress. But the court agreed with us in terms of Section 22(3) of the law, that it is unconstitutional because of its ambiguous nature, especially in defining unlawful means, of obtaining data and more. And the court thought this would endanger privacy rights. But also the court agreed with us in terms of Section 23, subsection 3C and E, that they're unconstitutional for lack of clarity on consent for data collection, who is capable of providing consent, but also who is capable of entering a lawful agreement to provide data from an institution, from an individual perspective, from a representative, and more. But also, before I finish, the court agreed with us that prohibition of collection of personal data by unlawful means is excessively vague and potentially conducive to legal uncertainty and abuse. And this speaks to the previous provision that you are limiting data collection by unlawful means, but you're not clear enough that what are those unlawful means. The last is the ambiguous in the delineation of reasonably practicable compliance or lawful purposes that might, prompt an institution or, data controller or data protection officers or a public agency to say, this data was obtained for lawful purposes, or this data is here, and if you acquire it in this way, it's going to be deemed as this is unlawful purposes. So the court also thought that there's ambiguous in the framing of that provision, which might also makes it susceptible to abuse. Going forward, I'm finishing by asking questions that whether the stakeholders have any, opinions in terms of the court's ruling versus what the court didn't rule in our favor, but also the positive trajectory of data protection. Is this enough in terms of what court decided, or we need a more comprehensive conversation? Does the litigation means the road, the end of the road? And Miriam, to your question, you said we're in the Court of Appeal, and it's been more than a year since our colleagues, our compatriots, filed a notice of appeal. We also filed a cross appeal because we trusted that the court still needs to look into the contestations that the High Court did not grant. debates beyond courts, probably conversations like this, inviting stakeholders and policymakers might prompt them to buy in our point of views. But also that's the decision to say anything about the lawmaking process. For us, we were discombobulated to learn how the process ends. In a situation where we had taken lead from the get-go. It was not. I mean, it was surprising to see how the process was now taken by other people within the parliamentary committees and craft something that was not a consensus over the stakeholders and the initial thinking. So thank you so much, Miriam. Happy to circle back if you like later, but at least this is the gist of what we had brought to court. But also a positive note is that this case also prompted scholarly conversations. I understand that academics have written quite a lot about this case. I've seen at least more than 5 articles published in journals discussing this landmark progress, but also the High Court has used it in deciding some of the cases. I understand our Data Protection Commission is been determining various disputes of for example, someone or a pub posting a picture of you in a pub having lunch. So we have seen some of these complaints, and this case has been useful in leading to the thinking of the judges. So thank you so much.
Thank you very much, Tito. I forgot I was the prefect for time because I was really enjoying the updates. This is one case I've followed for quite some time, and clearly we have a bit of a long way to go. And I really like the questions that you're asking. Does litigation mean the end of the road? What next? But as you've pointed out, such conversations and having such conversations is one of the ways of determining what next. So congratulations, obviously, to you and Council Kambole. I know you guys have done a fantastic job in taking this. Raymond, please confirm you're back. We'll have a lot of questions coming after we dissect these cases. So please let me know whether your internet is back or whether there's another internet shutdown while you're still recovering from a very recent internet shutdown, but conversation for another day. Are you back? Are you good to go?
Yes, Miriam, I am. Confirm if you can hear me.
Yes, I can hear you. So I will ask you to do this in 7 minutes because we've taken a bit of time from the internet issues, but I trust you to do it.
The internet issues are problems of all of us, third world countries. They are not unique to us in any way, but the shutdown as well. Anyway, I was sharing about the Google case. So we had 5 issues for determination, and the PDPO was tasked with answering the question on whether Google qualifies either as a controller, collector, or even if it qualifies as a processor under the Data Protection and Privacy Act. The other issue was on whether Google is registered with the PDPO, and if not, whether such non-registration constitutes a violation of the law. The third was whether the respondent's transfer of the complainant's personal data outside Uganda, so this was on cross-border transfers, having no prior approval from the PDPO amounts to a violation of the Act. The second last was on if these violations caused or were likely to cause damage, distress to the complainants and millions of other Ugandans who use Google services. And then the last one was on orders. So on the very first one, on whether Google qualifies as a data controller or a collector, yes, just next slide, thank you. For us, our issue was that Google collects a lot of data. So it collects your email, your date of birth, your nationality, your browsing history as well, your location data when you're ordering Glovo and whatnot. So it has all this information. And for us, we were arguing that them collecting that amount of information under the definition, section 2 of the Data Protection and Privacy Act, they do qualify as collectors and data controllers for purposes of our case. Google tried to, counter us with their global privacy policy, and they said, we acknowledge that we do collect, but then we have a privacy policy that we actually think covers all these issues that the complainants bring before the court today. And the PDPO found that as a controller and a collector, but it was not a processor, as it determined the purposes and means for which they collected and processed user data for millions of Ugandans, and that's couched in the interpretation section of the Act. Next slide, please. So the other issue, the second issue, was on the issue of non-registration and whether the non-registration constituted a violation of our Act. When we checked the register, the PDPO register on their website, Google was not a registered data collector. It was not a registered data controller as required by the law. And Section 29 of the Act, read together with Regulation 15 of our regulations here in Uganda, makes registration for those that collect and process data, personal data, mandatory. But Google sought to rely on an exemption, and I can really understand. Google is this tech giant that has profits in the hours or in the months that are equal to the GDP of Uganda. So I can understand when they say that, we need an exemption to this, and what we are doing is actually not a violation of the Act. But the PDPO did find that the regulations and the Act require registration, and if there is no exemption that has been gazetted, then Google cannot assert its, cannot invoke special treatment under the law and say that, well, I need to be exempted from the application of the law and so on and so forth. So here the general rule was simple. Relying on the case of Total Uganda Limited versus URA, the PDPO was of the view that the general rule is that registration is mandatory. You look at the couching of the Act. So the mere existence of an enabling provision for an exemption does not mean that that displaces the general requirement and obligation to register. On the third issue, which was on whether the respondent's transfer of the complainant's data. Next slide, please, Miriam. So the third issue was on cross-border transfers, cross-border flows, where we had Google taking or transferring personal data of millions of Ugandan Google service users for storage, but also for processing abroad in other jurisdictions. Our law requires that before you do transfer data across borders, whether it's for storage or other functions as might be allowed or permissible under your policies or under the laws in Uganda, you need to have, you need to comply with the gazetted areas or jurisdictions which have been vetted and actually have commensurate safeguards for protection of this data. So under the principles of data protection, data security or safeguard is one of the core principles in our Act. And the responsibility really falls on the Attorney General and the Personal Data Protection Office to do gazette certain jurisdictions and say the US is a gazetted jurisdiction for which we can have our data flow to for storage, processing, etc. UK is such a gazetted jurisdiction, etc., etc. But to the best of my knowledge, and at the time of this case, we did not have any such gazetted jurisdiction that was, vetted and had commensurate protections that can stop or safeguard Ugandan users from the risk of misuse, or even undermine Uganda's data protection framework and our digital sovereignty. So the PDPO, indeed, under Section 19 and Regulation 30, posited that the obligation of commensurate jurisdictions when it comes to cross-border data transfers and data flows is not solely one that requires approval from the PDPO for every transfer. As we were saying, it disagreed with us, but it agreed with us that there's a requirement to maintain accountability and also ensure that there are adequate safeguards when you take this data to other jurisdictions. The PDP also found that Google indeed failed to demonstrate that wherever they were taking this data had safeguards commensurate to what we had in Uganda. And, this would now be, this issue is, fertile for fomenting the discussion around how do we start treating cross-border data transfers or data flows in Uganda as compared to what's happening in Kenya and other countries on the region. The other issue was around harm, damage, distress caused to us by the violation, but also the continued infringement of the Act, as well as its regulations by Google for both us, the complainants, but also the millions of Ugandan users. Because we didn't bring this suit only in our name. In name, it is in the name of the 4 complainants, but in substance, it is in the interest of all Ugandans that do use Google services. So for the issue of damage distress, the PDPO did find that the failure to register, but also the lack of safeguards, occasioned real distress. There was also the lack of a point of contact, something I didn't share before. During the story and the preparatory stages of this case, we approached Google first. But like I had told you, it's big tech, and we are a small team of 4 people. So big versus small. They did posture. You write an email to Google LLC, and this email is actually received by an automated response machine that determines if it warrants attention from Google or not. So if it does, it's forwarded up the chain. If it's not, you get a response as we did. So this lack of transparency, the lack of accountability, the lack of remedy, knocking on their door and having no answer is what we did plead, among others, as to what could have occasioned this distress for us as the complainants. The PDPO agreed with us that indeed the failure and the lack of these safeguards, but also the absence of a point of contact. A data protection officer in Uganda. I know Google had at the start asserted jurisdiction, and it's similar with majority of the cases on the continent. We have colleagues who have worked on the WorldCoin case, as they'll be sharing later. When you look at the cases that are coming up, labor rights cases against Meta in Kenya, data labelers suits, the WorldCoin case, big tech will always assert the issue of jurisdiction, saying you have no jurisdiction over me because I'm not headquartered in Uganda. I have no physical presence, and therefore you cannot assert your jurisdiction
Right.
on
Raymond,
me.
I will ask you to
Yeah.
wrap up in 30 seconds. I have so many questions about this case, but just wrap
All
up.
right,
We'll
so
have a time to discuss.
yeah, as I wrap up, the issue of remedies is a complex one, and I think I'll go knocking on Tito's door very soon. Our act is also couched in a similar manner as that of that Tito was challenging. In terms of remedies, the PDPO is toothless, if I may say that. So all they can do is back, but they cannot issue compensatory orders against Google or big tech. Then the appeal mechanism is an appeal to the Minister of ICT. As Tito has already pointed out, that is problematic in its own way. Thank you so much.
Thank you so much, Raymond. I am particularly interested in the process, and you've mentioned an appeal, a potential Well, they appealed, but yeah, we will come back. We'll come back to that. And also a point you made, our commissions toothless, and how can they ensure enforcement? So very quickly, we'll jump to Kenya. In the shortest time possible, just take us through the WorldCoin case or Tools for Humanity. And I see fantastic questions coming through the chat. Just keep them coming. I'm really enjoying reading through. Again, after this Kenyan case, we will have an open discussion, and then we can have more conversations then. But Joshua, please go ahead.
Hi everyone, and hope you're good. Yes, but it's a bit unfair coming after Tito and Raymond. So quickly, yes, my name is Joshua, yes, from Kenya, and I'm Litigation Counsel at Katiba Institute, and I'm here to talk about the WorldCoin judgment on on what I call digital colonialism. To my mind is that the WorldCoin judgment, it shows us on what some are calling digital like a colonialism, that this is a pattern where foreign private and big companies come to the global south and they use the global south populations as a site for data extraction, data experiments, and mainly because there is the asymmetry in power dynamics, and also because most of the African states, their laws are not clear on the question of consent, and also because most of the populations are poor, and they are easily like swayed away by this induced like a consent. So in this WorldCoin case, what happened is that the WorldCoin and its subsidiaries came to Kenya, and they were collecting biometric data in Kenya via an app called OP, and this is the app here. Yes, that see that it will capture the people's iris. So I represented the applicants, and that's Katiba Institute, ICJ Kenya, and Kenya Human Rights Commission. And we challenged the legality of this process mainly on 4 grounds. One is that they had not conducted a data protection impact assessment. 2 is that the consent was not informed and free. This is because they were awarding people the cryptocurrencies in exchange of their personal data. And 3 is that they had not registered as data controllers or processors in Kenya. So when we went to court, it was mainly on 4 issues, but the main issue that they raised is that the courts in Kenya did not have jurisdiction over them because they were foreign entities and they were not in Kenya, and 2, that we did not serve them like with their pleadings, because we should have gone to Germany and the Cayman Islands to take our pleadings there. And 3, they also said that Katiba Institute was not personally affected because Katiba Institute did not give its iris, and as such we could not go to court. And they also argued that they were private entities, and such we could not sue them in claim for human rights. So quickly on jurisdiction, the court found that the applicants who could not go to the office of the Data Commissioner. This is simply because under the Data Protection Act, for you to go to this office, then you must be a data subject, and a data subject is defined as a natural person. Katiba Institute is not a natural person, and therefore we could not be made to go to the office of the Data Protection Commissioner. And then on locus standi, The court read Articles 22 and 258 more liberally and said that one does not require to suffer a personal injury for him or her to go to court, and people can go to court on public interest grounds. And then the court considered the issue or the lack of a data protection impact assessment, and it held that the OneCoin Foundation and the subsidiaries, they could not start the process of collecting the people's or the personal data without this impact assessment. Then the court, in an interesting way, it reads the Data Protection Act to say that it is a normative derivative of the Constitution. This is to mean that even if it is a procedural violation, this on its own, it also constitutes a substantive violation of the right to privacy. This is because the Data Protection Act, it was enacted so as to give effect to Article 31 of the Kenyan Constitution, which provides for the rights to privacy. And then the other link, it was that the Data Protection or the OneCoin, they were required to register as data controllers and processors. And for as long as they had not registered as such, then they could not even start the process of collecting the personal data. But the most important bit for me and from this judgment is how the court considered the other issue of consent. The court held that consent, it must be free and it must be informed. It cannot be coerced, or people cannot be manipulated or tricked into providing their consent. So we argued, and the court agreed that when the OneCoin, they were issuing their cryptocurrencies, they were basically luring poor Kenyans into giving their data, and as such, this cannot be said to be a free and informed consent. So this ties back to the initial theory of colonial of digital like colonialism, because they come and thinking that these people are poor, so we can give them like some few coins, and then we can extract their data. So their main like three hits from this judgment. One is that it is mandatory for any data controller or processor to conduct a data impact assessment before collecting the data. Two, the consent, it must be free and it cannot be induced. Three is that they must register as local data controllers and processors. But also again, and finally, is how the court crafted its remedy. It asked the OneCoin and Foundation to go and delete the data, and then it said that the process is not left to these private entities alone, but it must be supervised by the Office of the Data Protection Commissioner. And and this week the Office of the Data Protection Commissioner issued this notice here confirming to Kenyans that indeed such data has been deleted. So that is all from this judgment, and I'm happy to take any questions.
Thank you so much, Joshua. When I saw this week, that's what you're just I asked how do you verify that they've actually deleted the data, because they claim to have deleted the data. How do you verify? But thank you so much for everything that you did. It was such a huge case in the country. Of course, I remember. And for people who do not know, WorldCoin, it was co-founded by Sam Altman, who's the CEO of OpenAI and ChatGPT that most of us use. That was brilliant. Thank you, Joshua, Tito, and Raymond, not just for being bold, but taking on cases that very few people would take interest in, uncharted territory. But you're shaping how data privacy and data protection is being enforced in the region and beyond. I see there is about 69 of us on the call, and I imagine some of you joined as the conversation was going on. Thank you for making time. This is a special edition of the Data Privacy Day webinar by Paradigm Initiative. And for the past couple of minutes, we've been looking at a few quote-unquote big cases that have been shaping data privacy enforcement in East Africa and what exactly we are learning from that. From the presentations, I have more questions than answers, and I'd like to get into them. And I also see a few questions on the chat box, and I can see a few responses as well. This is turning out to be quite an academic, webinar, and I'm really, really enjoying the conversations that are happening. I want to bring in Rose. Well, she's not one of the lawyers that really pursued these cases, but she sits at a very vantage point. One, she has worked at the Data Protection Commission here in Kenya as Deputy Data Protection Commissioner. And then currently, Rose, I know you are advising the East African community on data protection and cybersecurity. There's a brilliant question that someone asked on the chat, and I'd want us to start. This is from Wanderi. And he notes, I think it was Raymond who was, making a presentation and said, Google, and the profits that come from Google they're way bigger than one country's GDP. And Wanderi is asking, is there a way that we can push the East African community to enforce regulations uniformly, as opposed to one country fighting its own battle, especially when it comes to big tech? Rose, what are your thoughts?
Yep. So one of the things that we're, and this is a wonderful question because I guess it segues into the discussion that we were anticipating to have. One of the things that the EAC, comprising of 8 countries, is doing is trying to find a way that there can be not just harmonization of the data protection laws, but also harmonization when it comes to cross-border disputes, so disputes that affect more than just one country. This would lead to, I guess, some sort of coordination with the data protection authorities that exist within the ATEC countries. And so this brings, the aspect of strength in numbers. So this is a conversation that is ongoing, seeing whether we can actually model something that is, I guess, akin to the EU with their supervisory authority in terms of bringing in cases and viewing cases. But again, this is still under consideration by the partner states of the East African community. But this would be a good way to challenge. The reason, and it's not a case, again, that is unique to, for example, Uganda. Kenya has also, when I was a data commissioner, deputy data commissioner, sorry, one of the issues that we used to have was that question of, well, how do we enforce compliance with multinational companies when they do have this view that, we are bigger than you, we serve multiple countries, and so if we wanted to, we could possibly even just put a kitty where we keep paying fines, and it wouldn't affect any of our operations. It's easier to pay fines than actually to comply. So having that strength in numbers would actually ensure that we're enforcing this. And this is not just from an EAC perspective, but also on an African perspective, because again, this is a conversation that is being had with the AFCFTA in the aspect of cross-border data transfers, and how do we actually ensure that regulatory institutions such as the data protection authorities are able to speak to each other and enforce in a manner that is coherent, as well as ensuring that the protections of I guess the African population is being done, not just when it comes to country-specific issues, but issues that affect Africa as a whole. So I
Thanks,
think this is
Rose.
a conversation that needs to be, to be had aggressively, but it is happening within the EAC at current.
Okay, that's wonderful. When you're speaking, I was trying to see practically how this would be enforced, and I'm really keen to see what the EAC comes up with, because you also need to balance sovereignty and national security, and then also issues of data protection, and then there's also AI, and I mean it will be fascinating to see what EAC comes out with. And I'm also curious, have you, from your experience, seen any other regional bloc that we can borrow from? It doesn't have to be within Africa. I know Europe is quite strong on data protection through the GDPR. So is there some practical elements that we can borrow from different regions that you've seen?
I haven't actually seen outside of the EU an instance of regulatory coordination, although there are instruments that provide for regulatory coordination when it comes to enforcement. Most times, and this is, for example, I think there is the APAC, which is now the global CBPR aspects, cross-border privacy rules. It also has an enforcement component in it. However, this hasn't actually been practically enforced. And so what this is really just an agreement amongst the participating countries to say if there is any instance of enforcement issues, and we can cooperate with each other to see how we can then move forward to work together to not just investigate, but enforce certain actions that have a cross-border effect on the countries that are participating. Now, again, as I've said, this hasn't actually been seen in action, at least from what I know. And so the EU is probably the strongest aspect of this. One of the things also that's being looked at, which I think will be interesting to see, is as part of the EU's adequacy decisions, there was also an aspect of coordination for enforcement. This hasn't again taken effect, and could possibly see coordination amongst EU partner states and countries that have been deemed adequate, including Kenya, if it does get that adequacy decision on cross-border function in terms of enforcement. But regionally, I guess with the decisions that have been done with Uganda and Kenya through an MOU, I don't know that they're stringent enough to see this happening as a regional bloc. So everyone would have to kind of enter into their own bilateral agreement or a multilateral agreement that is coordinated either through the EAC or partner state to partner state. But having this regulatory framework that actually encompasses some of these issues would then do away with the aspect of having MOUs and kind of have this framework that enables cross-border coordination with regulators to actually make determinations and enforcement action against some of these big tech companies and even smaller regional organizations, as has been seen.
Again, it will be really fascinating to see how this pans out. And I'm sure, I think a lot of people here would have suggestions. So feel free to throw, your suggestions in the chat box. And yeah, let's all learn from each other and see how, as a region, we can adopt some of these mechanisms. There's something we had started speaking about with Tito, and also Raymond, you spoke to it. Some of the gaps that you identified as you're pursuing these cases. And one of it was, how do you enforce if a decision has already been made? And also Rose has spoken a little bit to it. But particularly Raymond, I know there is a not necessarily a gap, but when Google tried to appeal, and also Tito spoke to it a bit, so that appeal mechanism is not, or was not fully thought out. Correct me if I'm wrong, but I'm curious to see what other gaps you identified as you're pursuing these cases, whether at the commission level or yeah, Raymond, please speak to some of the gaps that you identified.
Yes, thank you so much, Miriam. So throughout the journey and the journey of the case, we did come across, or were met with a few roadblocks. But to start with, some of these are actually within the law. So the first challenge we saw was, and this is something Rose has already alluded to, the issue of fines. Like when you have small fines, they do not scare big tech. If you look at, for example, Regulation 30 of the Data Protection and Privacy Regulations of Uganda, they mandate that if you have a violation running, then you can pay 2 currency points each day for the violation. 2 currency points each day for the violation means around 732 currency points, which is the equivalent of $4,000 or 6.2 million naira for those who are in West Africa. Now, for a big non-state actor like Google, I want to qualify it as a non-state actor that has all this money and all this profit made every second, I don't think they would rather comply. Non-compliance is easier for them than compliance is, because compliance means that you have to subject majority of your operations within Uganda to some scrutiny or some accountability, which is done by the Personal Data Protection Office of Uganda. For Google, $4,000 a year. I mean, even for you, Miriam, $4,000 a year would be something small. You'd be like, let me part with that little and just carry on the way I would like. So the weakness and inadequacy in penalties makes it very hard to sort of get like a compliance coming out of that. The other thing we did notice was the institutional capacity. So there is a lack in institutional capacity. And I really apologize. I want to apologize publicly to the Personal Data Protection Office. I think we were unfair to the office. We did not understand what the dynamics of the office look like. When we had a meeting with the office, we discovered that they have 5 permanent staff. So as compared to the office in Nigeria or the KDP something from Kenya that has more staff, you understand? And then you also have an office that is not only understaffed, you have an office that has a budget. When you look at the budgetary vote, under vote 126 of the national budget, the PDPO has a budget of about $30,000, So you have someone who has $30,000 as the annual budget going to enforce against someone who makes $30,000 in East Africa alone in a few hours. So that also is affected the way they did operations and reached out to Google. The other challenge we did see was on jurisdictional issues, sovereignty issues, where you have policies, internal policies or global privacy policies of Google or a non-state actor like Google, as I had called it, versus the data protection law of Uganda. So you find the two are at loggerheads, and Google is saying, well, our privacy policy, global privacy policy, our internal policies actually supersede some of these things. So those were some of the challenges we did see. And recently, I think the European Commission has designated WhatsApp as a very large online platform, VLOP. So that speaks to the capacity, to the breadth of power, of resources, of influence, that these tech companies have, as compared to some of these offices that are very young and nascent, underfunded, having no capacity, as well as having laws that have few fines and are made in a way that creates a lot of uncertainty and lacks clarity. Thank you.
Thank you. Thank you so much. Brilliant. I was just noting down some of these gaps that need policy intervention, but that's again remarkable. And we could only identify the gaps through such cases. So thanks for pursuing. I want to bring in Tito. And Tito, I want to throw back the question that you asked. And I know you have been thinking through how to ensure we have not just compliance, but from the get-go, we get our laws right. And I'm asking you this question particularly because I know you challenged the Data Protection Act in and of itself, but then I'm wondering what would be the recommendations that you have so that when lawmakers or when a country is putting together a law, in the, an ICT related law, that they have human rights in mind and they have data protection, respecting, principles in mind, so that we don't necessarily need to have Titos every so often going to challenge provisions. I'm not trying to, ensure that you don't have a job, but it would be nice. It would be nice for a change to see that we are not challenging provisions in the tech space.
Yeah, I mean, I want to borrow the proposal by this participant is called Wanderi in the chat. It sums up what I would have said, and he put it very well that, for example, in the context of Tanzania, we do not need to mainly be bothered by the operational or procedural issues, while the substantive aspects of our governance architecture are not progressive. So this is for me, this is a massive takeaway, because if you look at the Constitution does not cater for independence of institutions of governance, institutions of democracy. So ultimately, you have a parliament whose quality of the deliberations is debatable. In fact, for example, in our case, our law was enacted in a parliament that is an extended party caucus. You cannot have a parliament that is 99% ruling party legislators. You end up having, diluted conversations. That does not really involve, someone spending the intellectual bandwidth to make sure that they interrogate questions. I mean, they interrogate ideas, provision to provision and more. But also the second would also mean that where do we go in case we cannot attain what we want through the stream of the parliament? I always want to applaud our Kenyans compatriot that at least you have a judiciary to run too, which sometimes gives progressive, landmark decisions. At least in the since when you architected it in a way that speaks to the current realities, the judiciary has been excellent. So if the popular way of doing things fails, that now the citizens cannot be fully involved, now experts cannot be fully involved, now perspectives cannot be fully involved, because one of the conflicting issue we get is data protection versus national security. And these are some of the discussions that don't make it to mainstream conversations. So if we fail to reconcile the two, why not run to the parliament? I mean, why not run to the court? And for you guys, at least you're advantaged that your judiciary is a bit progressive on the continent. And once you have such oversight institutions, you can also have an award that you are going to enforce, or you are going to claim that I need this award to be enforced. And that doesn't mean that Mount Kilimanjaro is in Kenya. So I retain the privilege.
You had to. All right, we unfortunately are running out of time, but I want to bring Joshua for probably a final question. You represent an organization, Katiba Institute, and we salute you for all the fantastic things you do on our behalf. But I'm wondering, what can we learn from you? How can we collaborate more with civil society to pursue such cases that you're pursuing? So how can courts, litigants, and common mwananchi, right? Ugandans will not understand Swahili, but you have to try. How can we collaborate to ensure that we do such kind of work for the greater good? Because you have a wealth of experience. How do you do it?
Thanks, Miriam. Okay. Yes, for like a start and on how we can involve like the public or the collaborations. And let me speak about the OneCoin case. One, I can say that one, the public noise works and the public noise helps. If you remember, the OneCoin guys came to Kenya in May 2021, and at that time we were nearing the 2022 elections. And due to that public noise, then the government formed, and for the first time, a multi-agency task force, yes, that consisted of the DCI, the DPP, and the Office of the Data Protection Officers, and the Attorney General. And it is this sustained noise from the civil society and also from the common Kenyans that helped the case, because I can disclose to you that it was for the first time that government agencies came to court to support us. It was for the first time that the Office of the Data Protection Commissioner came to court and said that these guys did not submit a data protection impact assessment. Do you know that normally what happens is that we normally allege, and then after some time you see a cooked data impact assessment that has been backdated. So yes, so one of the things is that I can say that the noise and the support from the people, because also judges are they are also humans, and sometimes they also want to feel that they have the support of the people, or they are being protected from the impact of their judgment. So one, it is the collaboration, and what I think it has helped Katiba is that we have the two wings. One is that we have the litigation and that we go to court, but but we also have the advocacy wing that normally it collaborates with other CA so like this, it also gives us both the moral and also the legal support. So yes, so that collaboration is very key for some of these big cases, because also sometimes and you remember that there is a time in 2022 when Ruto and Uhuru have classified Katiba Institute as a terrorist funded so because we were suing them, and it took the support of the other NGOs to come and defend us. So sometimes that support is very, very important in some of these cases. Thank you.
Thank you so much, Joshua. And as you're speaking, I was also thinking there's a role for media, and we need to completely engage media when we're pursuing some of these cases, because they also played a huge role in all the three cases, actually. So yeah, media, civil society, of course, the courts and the entire judiciary, and regulators. So we all really need to come together and ensure this happens. I want to bring Rose for a final word based on something you have said, because constantly there's political pressure. Just from your experience, and I know you've worked at the Data Protection Commission, how do you balance political pressure to ensure that you're keeping especially big tech accountable and external parties accountable? And I dare say that sometimes it may appear that the budgetary constraints that we've been talking about are at times intentional so that they ensure that the commission is not fully independent. From your experience over the years, how would you advise that people who are pursuing these causes then are able to balance between political pressure and doing what's right? And sometimes you would remember that big tech will be in bed with government, so you're fighting against two potentially very heavyweights. And in, for example, Raymond's case, you're only the three of you or the four of you. What would your advice be? But before you speak, we have a few minutes to go. I'd like to hear at least one or two people from the audience, and particularly in terms of solutions moving forward. You've had all these cases, you've had what is going on. How do we move from announcement to enforcement? What do you think we can do as a region, as East Africa and beyond? So let me just post that question. If you feel moved to speak, I will give one person an opportunity to respond, but please feel free to type on the chat box and we'll definitely read them out. But Rose, as the final word, how do you balance?
Wonderful. So I'll give you an example of a situation that we had. So this was just before I formally became the Deputy Data Commissioner. If you can remember, in Kenya, there was an instance of, this was even before the regulations came into place. So we just had the act without any roadmap for implementation. There were people that found themselves registered with political parties that they didn't know, and things like this. And this was a highly political instance. At that point in time, there was really only one employee at the ODPC. The rest of us were seconded. So it was just myself as a technical seconded staff, and Madam Kasait dealing with technical issues. Now, we didn't have any powers to actually coordinate complaints or anything of the sort. But what happened is the law clearly stipulated for the bare minimum in terms of rights protections. It stipulated what needed to be done. It stipulated that if information is collected or data is collected without consent or without lawful purpose, and it must, then there are remedies that would have to follow. Remedies were not available at the time to individuals, but they were deletion was an option. Enforcing some of these things was quite possible. So, and the budget at that time, if I can state, was minimal. In fact, I think we only were given 11 million for a year, which for an office of a data protection commissioner is very, very little. I think it's even less than the 30,000 USD that was being discussed. So one of the things I think is, yes, political pressures will come. But the laws are usually put into place to protect certain things, certain rights, and individuals as well. I don't think it is reasonable, especially for institutions that are given mandates that are very specific, to bend to political pressure simply because their funding isn't there, or simply because say, for example, big tech is in bed with the parliament. It is for the institution to be independent and to conduct its mandate in a manner that is independent. It seems easier said than done, but this has been shown in Kenya, especially with the ODPC, in various instances, including holding government institutions accountable, auditing of government institutions, and the like, regardless of the fact that the money does come from Exchequer, which is government, really. And so one of the ways that we've been able to do this, and kudos to, I guess, the civil society organizations that persist or that push forward in Kenya, is because they hold these institutions accountable. We've been able to actually fight and say we're doing this for the Kenyan, and so it's something that has to be done. And so having that independence, having that moral standing and that ethical standing to say that the law has really specified that this is how we should move, and so we should move regardless, because we're also held account to the same standard. If we are not doing the work, then the funding won't come. International organizations aren't able to take us seriously. Funding even from international organizations and donor organizations isn't able to come because we're not doing what we're meant to be doing. One of the other things I think that you need to consider is that data protection, even regardless of the issues of political pressure in country, is something that other organizations outside also look at when it comes to investments. People want to be able to see that there is an institution that can actually enforce the rights of organizations, can actually be impartial to some of these political issues. And so they also invest on the basis of that. So it's not just a good case for human rights, but it's also a good case in terms of economic growth. And so that's kind of the balance that some of these I guess, institutions that deal with the regulation of data protection need to look at. It is not impossible. It has been done. And so, as Kenyan lawyers like to say, the law is clear, and so it must be followed.
Yeah, I love that. Political pressure will come, but a luta continua. We must do what must be done. Thank you so much. I'm usually a bit skeptical when Kenyan politicians say the law is very clear. They mean totally different things here in Kenya. But for the lawyers, yes, the law is very clear. Thank you so much. I am buying time to see whether there is a hand that will go up. Someone who is moved to speak to the last question I have asked. If not, it's okay. Do not feel pressured. That's fine. We'll definitely continue this conversation. And as we wrap up, I have some bad news and some good news. I'll start with the bad news. We have come to the end of this conversation, unfortunately. The good news, if you joined us a bit later or in between the conversation, this will be live streamed and it will be available on Paradigm Initiative's YouTube channel. And this is not the last of this conversation we are having. As an organization, we are quite interested and concerned on everything digital rights, of course, including preserving and promoting the freedoms and all freedoms and such as data protection and the laws and freedom of expression and all that good stuff. As I wrap this up, I see a lot of lawyers represented. I need to mention that as Paradigm Initiative, we pursue strategic litigation a lot. So in case you find yourself struggling with a case or you've identified digital rights violation, be it on data privacy or whatever, feel free to reach out. You can reach out to me through my email. I will post it here. If it touches on East Africa, even if it doesn't touch on East Africa, just feel free to share or report on our reporting platform, Ripoti.Africa. That's Ripoti in Swahili, RIPOTI.Africa. We'll definitely get the reports, and as much as possible, try to support you through the case or work with you through that case. At this point, I like to keep my promises. I said we will finish at exactly 1:30 p.m. But my key takeaways or my key highlights from this conversation, I took away 3 key things. Number one, we all agree that litigation is becoming a critical accountability tool in the context of regulating and regulatory enforcement within East Africa and beyond, but particularly East Africa. The second thing I'm taking away from this discussion is that data protection authorities really must be empowered, and that is technically, financially, politically, because they have been put at a position where they should respond to quite complex cross-border data practices and all the issues that we've spoken about here. The third thing that I'm taking away from this debate or this conversation is that privacy violations do not entirely stop within national borders, as we've seen from the case of Google and WorldCoin. And so we really need to rethink how regulation looks like. And maybe, perhaps, it's time for us to rethink those fines because, as has been mentioned, sometimes they are peanuts. While Raymond Raymond, you mentioned I could afford $4,000. Maybe not. maybe not. But it's about time we start rethinking, is this really working for us as a region and as a continent? And in close relation to that point, I think regional cooperation is a must. And it matters now more than ever. Rose, you have a task ahead of you. As you can see, a lot of us are looking up to the EAC to fight our battles and also to collaborate. And I am quite positive that we can actually, show other regions direction in terms of harmonizing issues around data protection and cybersecurity. That was a mouthful. But on behalf of Paradigm Initiative, I'd like to say thank you sincerely to our speakers, Rose Musero, Joshua Malidzo, Tito Magoti, and Raymond, and of course, in absentia, Tobekile Matimbe, who's the Senior Manager at Paradigm Initiative. You have made this discussion worthwhile. And to everyone, all the 70 of you, I saw 70, but people have been dropping off, of course, due to other reasons. All the 70 of you for allowing us to spend Data Privacy Day 2026 with you. Thank you for all your questions. Could not have been possible without you. And as we wrap this up, finally, I urge us all to remember that enforcement is a must, and we all have a part and a role to play. And I will finish by using Rose's words in verbatim, that political pressure will come. And in my words, a luta continua. I wish you all a fantastic, wonderful afternoon and enjoy the rest of your week. My name is Miriam Beatrice Wanjiru, Programs Officer for East Africa. It has been lovely coordinating and moderating this webinar. Until next time, thank you.
Thank you.
Thank you. Bye-bye.